Christina Mulligan, and Shakira on this troika. So, Chris.
So I just thought, I'm curious about a bunch of stuff. One is there anything like freedom of contract? Are there any limits to what kind of contracts the state can prohibit you from making? So I had a student a couple of years ago who just couldn't get it out of his head reading the text of it. Like, seems like you've got to have at least some minimal ability to make contracts. So the Civil Rights Act of 1866 gives the right to make and enforce contract. Is it? I'm just curious about the materials. Is there anything about the right to make the contracts or just enforce them? Second thing, I guess you just mentioned about Ogden versus Saunders. I'm curious what is why do you think Marshall had it wrong there? Doesn't that kind of suggest that if he was wrong in Ogden, that undermines to some extent his credibility in Fletcher? And a third thing I'm curious about, both Fletcher and Ogden are two of the very first cases with really clear articulations of the standard for judicial review. And Marshall and Fletcher goes out of his way. He says it's not just that contract clause means this, but it's clear. And do you really think? I mean, you're pretty tentative with your own assessment of the material. Do you think that was going on? I'm curious. Just in the discussions, did they think there was a clarity requirement? And then Bushrod Washington in 27 says it's got to be beyond a reasonable doubt. We always say it's beyond a reasonable doubt, citing nothing. But what do you make of the burden of proof?
So a lot of the examples that you use are the land grant cases, and it strikes me that they seem so legally confused in several ways that it may tell us little about the contract clause other than that it's used opportunistically. Because in these cases we have completed sales, and that raises the possibility that there is no contract because the contract has been satisfied, the obligations have been completely satisfied, and title has shifted, and there's nothing to impinge. And so it seems like that the lawyers in the case really wanted was to be able to incorporate the takings clause against the states, but that wasn't available to them at the time. And so they make this argument about that this is really a contract, and so we get this federal hook in there. And so does that mean that they're, granted this is the practice, it's what they were arguing, but does that mean there were public contracts, or does that rather that this extended to public contracts, or that they and the judges were just kind of results-oriented when they saw something that seemed, extremely unjust?
So first I want to just point out that the textbook I use actually has maybe about 4 or 5 cases on the contracts clause. So we do spend a day on it in my con law class. I'm very hard. So I think you have a very easily acceptable premise here, which is that Article 1, Section 10 sort of is among those economic interests that are protected in the Constitution, and this idea that entering into contracts, engaging in trade, commerce, all of that is an individual right. And I guess one of my questions, or my main question is would it be a reasonable conclusion that the framers, in addition to the concern about states reneging on their debts and obligations and all of that there was some intent that this clause sort of protect the right to purchase humans, and in the sense that contracts clause would prevent a state from failing to enforce a contract that involved the sale and purchase of slaves, which is a huge concern amongst the framers about whether that right exists as a right. And I think there may, I don't always take where things are in the Constitution as indicative of sort of what they concern or what they mean, but I think it is somewhat interesting that the Contracts Clause comes at Article 1, Section 10, where the clause before it, Article 1, Section 9, sort of prevents Congress from prohibiting the sale and purchase of slaves, and then sort of the next article prevents somewhat slaves, arguably, from doing the same thing. So, and so what I guess is that a thought, and is there anything out there that would seem to support the argument that this is also amongst those provisions in the original document that protects the buying and selling of individuals.
Okay. Series of very interesting questions. Let me see if I can do them justice. I do not understand the contract clause to have endorsed the freedom of contract notion that would later evolve under the due process clause of the 14th Amendment. I know it has been argued otherwise. Richard Epstein has argued otherwise. Richard and I have exchanged views on that subject. But I do not think that that's a tenable argument. I think the contract clause was framed to deal with existing contracts and did not, in and of itself, limit the ability of the states to control making future contracts and make them illegal or put various limitations on them and whatnot. I'm not taking any position here about the freedom of contract doctrine under the 14th Amendment. That's a topic for another day. But I don't think that the contract clause lends itself to that. Now, Marshall and Ogden comes very close to really suggesting that in his dissent, but I don't think that argument ultimately can carry the day. As far as Ogden relating to the other contract clause cases, it comes relatively late in the line of famous contract clause cases that Marshall would render. He is forced into dissent on that one. That could be that his clout with the court is not what it had been some years earlier, or it could be that he has frankly just pushed it beyond what the majority of the court would accept. But he certainly did a great deal to flesh out the contract clause, and we all know the famous cases. As I have discovered, it's very hard to get up and say anything fresh about the Dartmouth College case. Let me tell you, that's been beaten to death by everybody. Land grant cases, yes, a lot of the early things did involve land grants. Of course, that was also true in the opinion with Justice Patterson and Van Horn's lessee. Land grants were, of course, a kind of early form of speculation, likened by some people to an early stock market. And great many of the elite figures of our founding era, as you well know, were up to their eyeballs in land speculations of one kind, starting with George Washington, one type or another. So it's not surprising that there would have been a lot of land grant cases, or that Marshall, who incidentally himself was a bit of a land speculator, might have seen that as a very important area. Okay. Could that be analyzed as a takings case? I've seen that argued, yes. Of course, that was not available to him. I don't think it's necessarily inherently wrong to suggest that a land grant is a form of a land contract. And you know, this was a complicated situation with the Georgia Yazoo. They sold it to certain private companies, which then resold to people who claimed to be, and maybe were for that matter, claimed to be certainly bona fide purchasers. That's complicated the whole story. As you know, ultimately, of course, Georgia resisted, and eventually Congress voted a settlement to clean this matter up. But the Marshall opinion was very important, A, in leveraging that settlement, and B, in establishing that the clause extended to all contracts, public or private. The question of slave contracts is a very interesting question. That's a very interesting question. I do not know of any contract clause-based arguments against the abolition of slavery in those states that were in the process of abolishing slavery during the period right after the American Revolution. As you know, a number of states began to take steps in New England and in Pennsylvania, and somewhat more belatedly in New York, take steps to abolish slavery. I don't know of any contract clause-related arguments. I do know of takings clause-related arguments. It was argued in several states that the abolition of slavery would be compensable. And in fact, this, I think, may have delayed the abolition of slavery in some states, because while we were all against slavery, paying for things is expensive. When you have to pay for things, as Justice Brewer wrote in a famous opinion, it tends to slow up people's enthusiasm sometimes, right? So that was a factor, I think, in delaying it. And New Jersey didn't abolish slavery until quite late, actually, 1840s or 50s, I think, before. It was the last northern state, I think, to do so. And I do know that the contract clause, the takings clause was raised there as an issue. Now, that doesn't mean that slavery had no relationship to the contract clause. In the immediate post-Civil War era, Reconstruction governments in a number of states enacted laws which said, in essence, there can be no suits brought in the court of this state to enforce slave contracts. Well, there were a number of slave contracts out there, as you can imagine. Slaves had been bought and sold certainly into the Civil War period. And this case went to the, in fact, a couple of them went to the U.S. Supreme Court. And you know what the argument is going to be. This law constitutes an interference, an abridgment with the slave contract. And we should strike it down as a violation of the contract clause. And guess what? The Supreme Court agreed. They found these laws to be unconstitutional in violation of the contract clause. Now, that did not, I emphasize, restore slavery, but it did mean that whoever had a slave contract could now proceed to sue, to enforce, and to collect, even though the consideration, if I may phrase it that way, was now illegal. Now, if you find that a bit incongruous, only a few years after a bloody Civil War, I leave you to ponder.
Next troika is Brian Wildenthal, Larry Solom, and Will Bord. Brian.
Yeah, I give first kind of just a general appreciative comment. I think it's a fascinating article, and we do try to teach in my con law class. We've gotten some pressure to be sure to include it because it apparently is tested on the California bar, and we're told and it's covered. So I have tried to squeeze into one day span.
I'm flabbergasted to hear that any property rights things on the California bar.
Oh yeah, stranger things. Yeah. So I personally I always kind of more interested in the application of originalism, these obscure provisions, more than theory. So I just thought it was fascinating. And the one part of the broad point that I found very valuable is because although I do teach it and try to squeeze it in, I haven't really thought much or studied much about it. But really, it was not until reading this paper that it really brought home to me that made sense of the fact that the contracts clause only applied to the states and not the federal government. I was always aware of that. Clearly, couldn't be an accident, but I was like, that's kind of odd. Like, why didn't they? But really, it struck me that when you consider that conscious choice and then the bankruptcy power granted to the federal government, it really all makes sense. And so that's probably very familiar to you, but I would suggest maybe that might be something valuable to really emphasize and highlight, because that could really clarify it for a lot of people that, as you say, it seems the implication is that the founding generation trusted Congress to legislate in this area, but not the states. And that there's a lot of, that's very plausible. At a narrow point then, it's largely Judge McConnell covered it, I think, about this one Federalist, William Davey in North Carolina, who expressed the view that it only covered private contracts. And maybe I can tie this into this general issue. Professor Ely said, can we, he invited some suggestions about theory. Of course, if we're really looking at public meaning, then all the stuff about the drafting convention is, the secret drafting history, and really doesn't matter in a sense. I think Professor Ely has some interesting arguments that maybe it would cover public contracts based on the drafting history, but then Judge McConnell really, I thought, fought him to a draw and suggested really when you look at the drafting history, maybe it doesn't. But really none of that matters because that was all secret. What's really important is what the public was aware of. And in that sense, I think Davey deserves a bit more importance. I kind of just push a bit further the point that, that Judge McConnell already made. So when you say that it goes without saying that a single statement is a slender basis for generalizations about the thoughts of the framers regarding the scope of the contract clause, but it's not such a slender basis for generalizations about what the public would have viewed as the meaning of the proposal they were presented with. So from the public standpoint, they're told by a leading advocate of the proposal, don't worry that this only deals with private contracts, it doesn't deal with public contracts. They know nothing else about the secret drafting history. I think they would rely on that. Then you have an opponent saying, oh, it covers, public contracts, but then opponents always would exaggerate, in the scope because they oppose it. And so the public might say, well, we'll trust the advocates and we'll rely on that. And so I think there'd be a very powerful public meaning weight that could be put on that. On the other hand, there's the fact that the Northwest Ordinance, which was very public, only cover private, and then the public text does not, leaves out that limitation. But, so it's kind of, I think it's a very close, interesting question there. And so that maybe that issue about whether we should rely on, the public meaning accessible to the whole body politic versus framers' intent, that's something where the new originalism would, I think, would affect the weight we would put on that evidence.
Larry.
Playing off exactly this point. So the first thing I want to say is just this raises the meaning of meaning question, right? And so assuming we're going after the public meaning as communicative content and not the public's belief about the application to this particular question, then the first thing we would need to deal with is the text, which obviously does not differentiate between private and public contracts. So the next step would be to ask if the public context of constitutional communication was such that there could be some contextual enrichment here that would add a limitation to private contracts. And so one possibility is that the word private would have been understood as implicit in the clause, right? That it's just left out, but everyone would have understood that the word implicit is in there. The word private is implicitly there. For various reasons, that seems implausible to me. A more likely candidate, I think, is the argument that Michael McConnell made, which would be an argument that there is a presupposition of sovereign immunity, a background universally presupposed sovereign immunity principle. That argument, it seems to me, is plausible at least, but it runs into the Chisholm v. Georgia problem, right, that so many people did not seem to say, and the suits that are brought immediately, that so many people seem to see this as contestable, right? And if it's contestable, then it's not part of the communicative content. At any rate, that would be the way I would try to parse out whether or not private is somehow there or sovereign immunity is somehow there operating as a defeater.
Will.
So I guess we didn't quite plan this, but this works out well. So one other reason I would wonder about the sovereign immunity explanation is if that's right, you would expect state legislators who take an oath to uphold the U.S. Constitution to still have to worry about whether or not they are violating the clause, regardless of whether or not they're going to be sued. I don't know if we know whether they did worry, but the question of whether it's enforceable and the question of whether it's binding would be slightly different. So I wonder if there's a different kind of background principle that might explain a public-private distinction, which is that there's a sort of anti-entrenchment norm, of course, for governments, and we worry about their ability to bind themselves. And I assume, I'd be curious to know, I guess, I would assume if the clause did extend to public contracts, you'd have to worry about, and you'd expect people to worry about questions like, well, can the legislature just sign a contract that says, so-and-so is the king of Georgia permanently, and all of his descendants, or things like that, contrary, because if that provision is entrenched by the federal constitution, it would presumably trump all of state law. I assume not, because I assume there's some implicit set of rules about capacity or consistency with state law that would influence this, and that would make me wonder if maybe there's some implicit rule that when state legislatures make contracts, there's some implicit capacity limitations on what they can promise that bind future legislators, which would end up meaning it doesn't really apply. And I'll just note as a textual point, I guess in addition to the word private dropping out, words like bona fide and not procured by fraud also drop out. I assume that those are still part of the clause, that fraudulent and fake contracts are not protected by the clause, but if that's wrong, I'd wonder. So I guess I wonder if that set of things is a different way in.
All right, another trio of very, very good questions. Brian, your question and your comment is a very interesting one. Of course, Judge McConnell has written a piece that I have cited and, in fact, taught a number of years when I was teaching this material at Vanderbilt as to why the framers applied the contract clause and the Fifth Amendment, of course, takings clause differently. But I won't rehash that. Davey is an interesting character. He was speaking at the North Carolina ratifying convention. To refresh your recollections, North Carolina was one of those states that voted down the Constitution. So Davy is really speaking to a difficult audience. If you look at his comments, too, he seems to wander a bit into paper money, which is incidentally often confused in the discussion of what money states could issue was somehow linked into the contract clause discussion, suggesting that some people didn't have a terribly distinct understanding of this. My feeling, though, is that you have one person in one convention in a state that did not actually ratify, who seemingly openly endorses the narrow view. But other evidence I found persuasive, the change in wording, the opinions of figures that I think, frankly, were more influential than Davy in this ratification process, and I felt that they trumped. Davy is often pointed to, you're quite right, if I recall, Benjamin Wright points to Davy. He somewhat casually assumes Davy is actually telling the unvarnished truth, and you could quarrel with how I've handled it. I mean, how I've handled Davy's opinion. He was not, I think, it's fair to say, as major a player as some other people in the field. Okay. Public context, I find it a little hard to find that private is implicit. I agree with Lawrence on that point. It's difficult to know what the public context is. What does the public understand? I have looked at newspapers. I have tried to read the anti-federalist papers, so-called, the people who lambasted the Constitution. I've tried to become informed as to what extent opposition to the contract clause was a major source of concern. It is very difficult to work that out. As I quote in my paper, at least two prominent anti-federalists actually admitted the states hadn't acted very well, and maybe some type of limitation on state power would be desirable. I think that there's a great deal of debate about the Constitution, but it's conducted at a different level for the most part than fixating on the contract clause. As you know, there was endless conversation about the power of the executive and what the judiciary would be able to do, and were we establishing, an aristocracy? I mean, that's the kind of level that a lot of the debate was carried on. You find very little specifically focused on the meaning of one clause. So it's hard, I think it's very hard to reconstruct that. I suppose then as now, a lot of people weren't terribly well informed. And basically it came down, were you somebody who thought that a stronger national government was in the interests of the fledgling United States or not? And there's a lot of literature about how people divided Federalists and Anti-Federalists. And it's not even clear, I suppose, that a majority of people favored the Constitution. But it is clear that a majority of people who were politically organized and people in urban areas and people who had access to media favored the Constitution. And I think on the whole, the proponents of the Constitution out-hustled the people who felt negatively toward the Constitution. Will's question really asks me, I think, what is a contract? And that's a very interesting question. What is a contract? Does any time the legislature passes any law, does that constitute a contract? That couldn't be, right? That's not workable. Legislatures, for the most part, legislate. Now, I don't know of any contract which declared that someone would be the king of Georgia. So that's a little far afield. I suppose we do have a guarantee of Republican government, so that might run afoul of another provision. But nonetheless, that's a very interesting question. What is a contract? Let me come up in this context, which was bitterly contested. Tax exemptions. To what extent can a state grant a tax exemption that is binding on subsequent legislatures? Now, as you know, Marshall held that a state that was a contract. A tax exemption was a contract. Well, put yourself in this context. Sometimes legislators would grant seemingly tax exemptions in perpetuity, or at least for very long time periods. And as time moved on and circumstances changed, a lot of people began to ponder, this is very inequitable. I mean, the XYZ Corporation has a tax exemption seemingly in perpetuity, and that affects the taxes that everybody else has to pay. So there was an enormous amount of attack on these tax exemptions. And courts who would occasionally say, no, it hadn't meant to be a contract, it was simply a general policy of taxation, which you're free to change. But insofar as tax exemptions were contained, as they often were, in corporate charters, they looked very much like they were part of a contract. And throughout the 19th century, the Supreme Court repeatedly upheld some of these controversial tax exemptions, which brings us back to the question, what is a contract? And the Supreme Court and other courts had to wrestle with that in a variety of contexts. I was talking yesterday, and is marriage a contract? Certainly has elements of being a contract. Is marriage such a contract that the state cannot authorize a divorce? Well, I can give you the short answer to that. No. Marshall held early that the contract clause pertains to property and commercial matters, not to highly domestic and personal arrangements such as marriage. But that was not an implausible argument if we want to debate what is a contract. Clearly, you can't take the position that every time the legislature passes any law, it's fixed in perpetuity. That's utterly unworkable. And in fact, the Supreme Court never took that position. But I think tax exemptions, they're not quite like declaring someone a king, but they're on the way to giving someone a special exemption. You got another troika, don't we?
Just a few comments about this. So Larry thinks it's improbable that the word private might have been implicit. There is, of course, evidence that a number of people at the time did find it implicit. People who quickly summarized the contracts clause and stuck the word private in. So Charles Pinckney did this in the South Carolina Convention. Alexander Hamilton does it in his discussion of the contracts clause. It seemed natural to many of them, and maybe the sovereign immunity explanation is it. Maybe there's some other explanation, but I think we know that that it was implicit. The William R. Davey discussion, I think, is kind of interesting because it raises the methodological question of how do you allocate burden of proof in originalist discussions? Because Professor Ely essentially, as I read the paper correctly, it's sort of he's looking to see if there is conclusive evidence that that the clause is limited to private contracts, and he says, oh, only one Federalist actually said this, and that's of course perfectly true. But if you just say, well, I'd like evidence that public contracts were included, and there is no supporter of the Constitution argued that public contracts were included. You know, 0 seems to me to be a smaller number than 1. And so maybe we ought to look back to see what are there good reasons why we would have is the glass half full or is it half empty? Might have to do with questions like the ones Will Bode was asking. That is, you know, what would be the general sort of political theory considerations one way or the other? And Professor Ely quotes several arguing from Natural Law and Natural Justice. William Goodloe Harper's quote on page 27 of the paper is a particularly good example of that. But there is a political theory on the other side that Will touches on, and that is the principle that every legislature is free to repeal the acts of a preceding legislature, that legislatures do not have the authority by ordinary legislation to entrench their policy decisions in law. A contract, if constitutionally embedded, any time a legislature wishes to control future conduct through the means of a contract, it can entrench policy. So this is what creates the Charles River Bridge problem. The tax exemption problem that Professor Ely refers to is another excellent example of that. One of my 2 articles was about the problem of consent decrees, in which one administration would enter into consent decrees with friendly parties and then embed their interpretation of the law into the future. There's something wrong with that, and it may be that that is the reason why you might actually look for evidence that they really did intend to create that problem by including public contracts, rather than to look to see if there's conclusive evidence the other way. But I do think we need to be careful about modes of argument in which we say, there's not much evidence here, and therefore I win. Maybe there's not much evidence here, and therefore the other side wins.
My next troika of those of you who out-hustled others to get on the queue are Larry Alexander, Kurt Lash, and Ian Bartram. Larry?
Yeah, actually, Christina raised the question that I was going to raise, but I'll try to put it in a broader context. So the contract clause as a retrospective, limited to retrospective application, is one of those clauses, along with the takings clause, that deals with the problem of legal transitions, where you have a right at time one, the right is extinguished at time two. And so, I mean, what was it? When I teach Fletcher versus Peck, I'm always, I ask the question, well, so this contract, the original grant seems to be consummated, and then there's, grants further down the line. And, if the contract clause didn't apply, and there was no takings clause at the time, if my title to Blackacre today, somehow it can be traced back to a governmental grant, from time out of mind, the government then says, the original grant is invalid. We're going to repudiate the original grant. Therefore, when we take Blackacre from me, it's not a taking of property. You never really had good title to it, and the like. Now that it may be that in the back of Marshall's mind at the time, this was a a sort of scary scenario. And as far as the governmental, the non-entrenchment norm, it seems to me, I read a case a long time ago that from the mid-19th century, in which the court said the non-impairment mandate should be read as, well, if you impair, you must pay. You must pay just compensation, sort of as a takings clause to deal with this sort of transition thing. So that if we are going, if we grant you a right in a charter, if the legislature at time one grants you a right in a charter, the legislature at time two is bound to this extent, namely that if it wants to repudiate that, it must pay just compensation, so that the contracts clause be working as a sort of takings clause, taking of contractual rights. So anyway, the other thing I was going to ask about is the application of the contracts clause to increasing the obligations of one of the contracting parties. This comes up in Spanhaus, where the government doesn't impair anyone's obligation so much as it increases the obligation of one party. And now you can view that as sort of impairing the reciprocal obligation. I was obligated to do this for X amount, and now the government's saying you've got to pay me X plus Y amount. But I was just wondering what your take. I assume these may be later chapters in the book, but.
This is a great paper, and I think it's why I love originalism. You've called our attention to an assumption about the meaning of a text, and you've problematized it by pointing out a complicated history, and so I thank you for that. I think it's very nice. But you also challenged originalism, right? You also challenged us in terms of cherry picking and the problems with originalist methodology, and that's an important part of this paper as well. How should we go about understanding the original meaning? Is there enough evidence to come to any conclusions at all? And we're not sure. But in terms of doing originalism, and Larry and others have spoken to this, you would start with the text, right? And And then in terms of trying to understand that text, you try to understand what did that text communicate in terms of when viewed in the context in which it was originally delivered. And here we're not talking about a text referring to contracts, right? I mean, one of the things that you might do as an originalist is look at how was the term contracts understood at the time of the original enactment? And you'd look for patterns of usage, right, regarding the usage of the term contracts. But here we don't have a text saying do not impair contracts. We have a text saying do not impair the obligations of contracts. And so it seems to me what an originalist would do at that point would be to investigate common usage of that term. What were the obligations of contracts? So there's certain contracts that carry legal obligations and certain contracts that didn't carry legal obligations. And of course, that leads directly to Michael's point. In my understanding of the history, state sovereignty concerns would have been very much in play in terms of determining what kinds of contracts carried with them legal obligations. And it may well be the case that, again, in the context in which that phrase was delivered, it would have been talking about those contracts which carry legal obligations, and that wouldn't have included the public contracts. Now, this takes us to 11th Amendment territory and state sovereign immunity territory, and of course that's another area that we've had assumptions about, but which when you investigate the history, you find out that it's maybe a little bit more complicated. You had promises of preserved state sovereignty being given at the time of the adoption of the Constitution. You have Hamilton, of all people. Yes, I know he was lying, but you have Hamilton talking about how states were going to preserve their sovereignty, and the very concept of remaining a state at the time was presumed to carry certain immunities. And so I think you've got a literature, a wonderful body of literature relating to concepts of state immunity that I think might be very helpful to investigating not just a contract clause, but an impairment of contracts clause. And so I think you've opened up new territory and new opportunities for future scholarship. I think it's great.
Ian, I think my question's been asked and answered, so I'll yield.
Okay, let me take a stab at some of these, again, very thoughtful questions. Yeah, Larry, you do raise two interesting questions, both of which will be treated at some length in subsequent chapters of this opus. It was early established that a state could get out of any contract by exercising the power of eminent domain. So that, in a sense, converts it into a takings question. Indeed, it later would be established that even if a state had contracted not to use eminent domain, the eminent domain power would still trump. So that would become fairly early, during the Taney period, along with Charles River Bridge, that would become a limitation on the reach of the contract clause. State could always get out if they were prepared to go to eminent domain and pay compensation. Now, of course, that is the sticker, isn't it, as I mentioned before. A lot of ideas sound pretty good until you have to pay for them. Well, maybe not so much today because they could sound good and we just put them in the deficit. But in those days, they thought you actually would have to raise taxes to pay for things. And that might cool enthusiasm. But you could get out of something that was unwise, a franchise that was no longer workable or was antiquated. You did have an escape hatch. Okay. Let's see. Oh, yes. The point was the change of position. Was that it, of the parties? Yeah, second. Yeah, Spanhouse. Yeah, you're right. Changing the obligations. Yeah, that was certainly in the 19th century. There was case law holding that if you change the obligations of one party, made it more onerous for one party than what they had agreed to, you would impair the contract. Yeah, I mean, I don't think that was not even a particularly contested proposition. Much more contested is Kurt's point, the obligation of contract. Now, that too is a subject that I treat at some length in later chapters. Let me try to approach it this way. That gave judges fits. What was meant by the obligation of contract? It often was equated with essentially the remedial aspects of a contract. If a state took away virtually all effective remedies to a contract, but then said, oh, we haven't touched the text of the contract, that was seen as impairing the obligation of the contract. Some courts just paid almost no attention to the phrase and just treated it as if it was impairing a contract. That was a question that vexed a lot of people, a lot of ink got spilt, probably not very usefully, over the obligation of a contract. So I think you raised a very good point there. It's not one that I can unravel in a sentence here. Suffice it to say, it was a very real problem. Yes, I mean, I think the paper, I thought, would point in a number of different ways as to how one can assess historical evidence. History doesn't always yield conclusive answers. And as Mike has pointed out, it may be a matter of what your starting premise is. My starting premise is we look at the text says contracts. Therefore, unless I see some reason to assume that it was confined to one type of contract, I go with the text. But someone else could, in a sense, load the dice differently and come to a different conclusion.
Just two quick sort of linguistic points that come out of these questions. Note, Larry, you ask about altering the terms of the contract. Rufus King's proposal would have said alter or impair the obligations of the contract. That was dropped by the Committee of Detail, and yet Hamilton, when he, in his opinion, he says, what is impairing the obligation? It is altering or. So the dropping of a word does not necessarily mean that there was a deliberate attempt to change the meaning. Sometimes words are dropped because they're thought to be understood because of some other reason. I also have wondered about this language of impairing the obligation of contract is a kind of an odd way to refer to reneging on a contract. You might think that if the intention of the clause was to prevent states from repudiating or reneging on a contract, they might put it a slightly different way. I don't think this is conclusive, but it does have impairing the obligation looks a lot more like the state using its authority to interfere with something outside of itself rather than its own contract. So maybe that's another little clue to why the language is implicit.
Time has flown, and we've reached the 12:15 point. So, with apologies to Randy and to Jeff.
I'll be happy to talk to them about like any time.
Oh, that's. I don't believe it. Let's give thanks both to Professor Ely and to Judge McConnell.